morning, guys. I hope that everyone is well today. So this week we are dealing with the law of agency. Okay, but before we get on to our notes for this week, I want us to discuss the class assignment. It's uploaded and ready for you to complete. It's due towards the end of October. Please double check the due date on Learn, okay? So it's available for you to do. And secondly, there are practice questions that have been uploaded for you. So you have a few hours or a day and a half to deal with it before you actually do the test and see if you can answer those questions. And if you can't answer those questions, or if you're having difficulties in answering the questions, please then send me an email. We can have a one-on-one consultation, or if you are studying and you feel like you're not grasping the material, please send me an email so that we can set up a one-on-one consultation. Are there any questions with regards to admin? Maybe about the class assignment? Remember, guys, if you had completed only one of the 2 class assignments that were already uploaded, then you need to do task 3, which is your assessment or class assignment 3, because in order for you to get the 10% at the end of the semester, you need to have completed 2 out of the 3. Any questions? Can I get a thumbs up that you guys understand what needs to be done with regards to the class assignments? Thank you, Puja. Anyone else? Zama, thank you. Tivan, Tajal, Kosimpile. Okay, so who can tell me what they understand about the law of agency? Anyone? Tajal, what do you think? Tivan, law of agency? So think of this scenario. You run a business here in South Africa, and you'd like now to expand your business to another country. Okay, but your family is here and you'd like to stay in South Africa, but you still want to expand, and you see potential for your business to grow in another country. So you decide to open up another branch, okay, in another country. Do you think that you're going to be flying back and forth every time there needs to be a meeting? You need to fly there. Every time there needs to be originally signed, you need to fly there. Every time there's something that has to do with banking, you need to fly there. Do you think that that will be convenient for you?
No.
Exactly, it won't be convenient for you. So what you will do is you will appoint another person. So you'll give authority to the person that you've appointed to act on your behalf. And that person is called an agent, and you are called the principal. Let's look at this example again, okay? Now say the person that you've appointed, who's the agent, needs to negotiate a deal with the suppliers, okay, for your business, for the running of your business. Now this agent negotiates the deal. Who will the contract be between? Will it be between the agent and the supplier, or the principal and the supplier? Or will it be a contract between the principal or the agent? What do you guys think?
The agent and the supplier.
Agent and a supplier. Ooh. So you send someone to negotiate on your behalf. So do you think that contract will be between the person that you sent and the supplier? Or will it be between you and the supplier?
Me and the supplier.
Exactly, it will be between the principal and the supplier, okay? It won't involve the agent unless the agent is your friend or is your maybe business partner who owns 10% and you say, if you get a good deal, then we'll give you 5%. Then only the agent will have rights to that contract, only if the parties agree to it. So that's what we're talking about with regards to the law of agency. One person giving authority to another person to act on their behalf, and should a contract be concluded, okay, the contract will be between the supplier and the principal, the person who gave the instruction. It will not be between the agent and the supplier, and the contract will not involve the agent in any way unless the parties then agree that the agent might get some sort of compensation for it, maybe a commission or are going to be talking about the relevance of agency. We're going to talk about formalities, we're going to talk about capacity of the principal, and capacity needed for a person to be appointed as an agent. Let's firstly look at the relevance of agency. So the reason for engaging an agent is for convenience. So you don't have to be two places at once. Most of the time you're busy with one thing, you have another person that's dealing with at the other side of the business for you, if it is a business. So in business, people will typically act through others by conferring authority on other people's behalf, and the authority can be general or it can be specific. So you could give authority to an agent to say, run my business, okay? So the agent will do whatever is possible to run the business, okay? Negotiate with the suppliers, buy stationery, basically do every single thing, pay the employees that you have in that particular business in order to run the business. So if you say run the business, this person, then the agent will do everything possible to run the business. But it could be very specific. For example, telling a person to vote for you, okay, in a board meeting. So you appoint a proxy to vote for you in a board meeting, and you tell them how to vote in a board meeting. Okay, that could be the specific authority that you're giving a person. And usually it's only one act that the agent needs to deal with, okay? So agency is particularly important to juristic persons, which can only operate through natural persons who act on their behalf. So agency, usually we talk about agency with regards to businesses, because we know that a business cannot go and negotiate its own deals. It cannot go and talk to suppliers, or maybe if there is a legal issue, the business itself cannot then go and consult with a legal advisor. So the business will always have a person who represents it, and that person will be a natural person who always acts on behalf of the business. Could be a director, it could be a partner, it could be a shareholder that could be appointed to represent the business. Okay, so we find that because we talk about agency in relation to business, we think that agency or the law of agency or contracts of agency only apply in the business world, but that is not true. They also apply to natural persons who have never ever dealt with or managed or owned businesses ever before. You can, as a person, appoint another person to do or perform some juristic act for you. So the law of agency applies across the board. So what is the nature of the law of agency? So in commercial law, it is possible for a person to appoint another person to perform acts on his or her behalf, and the person who's performing is called the agent, and the person who is giving out the instruction or giving the authority is called the principal. So we need to make a distinction between your juristic representation or representative and your conventional representative. So by juristic representative, we mean that the representation arises as a result of the law. We don't have to have a specific procedure for that representation to arise. For example, if a minor is being sued or a minor is suing, okay, you know that a parent or a guardian will automatically be representing the minor or acting on behalf of the minor. So there's no particular process, it just comes naturally as a result of the law. In this particular session, we're not going to be focusing on your juristic representatives. We're going to be discussing your conventional representatives, or sometimes generally referred to as agents. So we already discussed what a juristic representative is: a person whose authority or capacity arises by operation of the law, and there is no particular process of appointing these representatives. For example, the right of a guardian to contract on behalf of a minor child. There's also a difference between your mandate and agency. So what is mandate? A mandate is, for example, where a client goes to consult with an attorney. The client will say to be giving the attorney mandate. The attorney is not the agent of the client, but is acting on the instruction mandated by the client. So there's a distinction between that two as well. Who is an agent? Remember, we said that we're not going to be focusing on juristic representatives. We're going to be focusing on conventional representatives, or formerly known as your agents. So an agent is a person who has authority to create, vary, discharge contractual relationships between the principal and the third party. So the agency is, in the strict legal sense, arises where one person performs a legally binding act on behalf of another person who become bound to the law or bound in law to the third party as a result of the agent's act. Remember, we said that the principal authorizes the agent to perform some juristic act, and should the contract arise from that juristic act performed by the agent, then the contract will be between the principal and the agent. So unless the parties specifically agree otherwise, the agent will acquire neither rights nor obligations in terms of the contract. Okay, the agent may be entitled to payment from the principal, but would not be bound in any way to the third party. So if there is now a dispute between in the contract between the principal and the third party, the agent cannot be sued, but there are exceptions to that general rule, obviously. So a further distinction can be made with regards to who's a true agent, okay, and persons who are often referred to as agents, but are not agents in the pure legal sense. For example, your estate agents, okay, the ones who help you buy and sell your house, they're not agents in your true legal sense, but they refer to as agents. So the agent's authority to act is based on the principal's consent, and the agent can be appointed only when the act to be performed can be performed by the principal. And if you look at page 283 of your textbook, you'll see figure 6.1, which we have here on the screen, that there are 3 parties that are involved in your agency. Okay, in the contract of agency, it's only 2 parties. Okay, the whole concept of agency, it's 3, but in the contract, the people who enter into the contract of agency are the principal and the agent. Remember, the principal gives authority to the agent to act on their behalf, to conclude a contract or perform some juristic act with a third party, and that contract or juristic act then binds the principal and the third party and does not bind the agent. And the exception is unless the principal and the agent have agreed that the agent shall get some sort of benefit or can be held liable in certain instances. Okay, can I get thumbs up? Are still together on the concept of agency, the nature, and the relevance of agency. Okay, let's look at formalities of agency. So what are the formalities? What needs to be complied with in order for a contract of agency to come into existence? So like you covered with Mr. Kruger, your formalities with regard to your normal contracts, okay? Remember, both the verbal and the written contract are valid, okay? Equally valid, okay? That's the general rule. But there are exceptions to the general rule. For example, if you are buying and selling land, the contract cannot be verbal, it needs to be in writing. Second exception, if you are entering into a marriage that's going to be out of community of property or out of property with accrual or without accrual, then it needs to be in writing. That type of contract cannot be a verbal contract. If you're going to enter into a contract of surety, okay, that contract cannot be verbal, it needs to be in writing. So besides those three contracts, every other contract can be valid or a valid contract if it is a verbal contract. So likewise, the formalities with agency, the general rule applies, except there are exceptional circumstances, okay, with regards to buying and selling land. Just like how the contract to buy and sell land must be in writing for it to be valid, the authority that you give to another person to buy and sell land for you will also need to be in writing, okay? So that's the exception with regards to your law of agency and your formalities in order for an agency agreement to come into existence or to have a legal effect. Let's now look at the capacity principal need in order for the principal to be able to appoint an agent, and what is the capacity of the agent in order for the agent to be able to carry out a juristic act for the principal. So generally, anyone with the right in law to do an act themselves will have a right to appoint an agent, okay? So capacity in the law of agency or in your agency agreement will correspond with the capacity to contract. So for example, under your general law of contracts, a minor does not have capacity to enter into a contract unless they are assisted by a parent, they are acted on behalf of, or they are represented by a parent. So it's the same with your capacity for being a principal under the law of agency. There are, however, certain limitations to this general rule. So the capacity will correspond with your capacity for your normal contract, okay? So where performance requires the principal's personal skills and personal discretion, then needs to be performed by that particular person, and that principal cannot appoint an agent to perform on their behalf. So personal performance will be required by statute. So although the principal becomes bound, it is not necessary that the principal be named, and usually this occurs in auctions. So you'll find that in an auction, if you want to sell maybe your car or your house or any item in an auction, you give it to a person who's called an auctioneer, and the auctioneer will then carry out the sale, okay? So although principals are bound, they are not necessarily, the law does not deem them to be named when this process goes through, okay? Or when the auctioneer then sells on the principal's behalf. If you look at page 284 of your textbook, in the case of Marias versus Perks, okay, so Marias was a farmer and he sued Perks, who was an auctioneer, who sold him what he thought was tick oil, whereas it was your sheep dip, and over 80 of his cattle then died. the court held that Perks had expressly acted as an agent and was not liable. Okay, and all that could be asked from Perks is to identify the unidentified principal who was now selling this so-called tick oil on auction, so that Marius can sue the principal who is unnamed. So it's not necessary that the principal must be named. For example, if I am selling my cell phone, but I give authority to someone else to sell my cell phone, okay? And the person says, hey, my friend is selling a cell phone, okay? The person that I give authority to does not need to name me as a person, okay? But when a dispute arises with regards to the cell phone, maybe there's a defect with the cell phone, then only the agent has a duty to then name me at that point. But at the time when the sale is going through, they don't have a duty to name the principal. So what capacity must you have in order for you to be an agent? So an agent is someone who concludes a legally binding act on behalf of another person without incurring personal liability. It is therefore not necessary for this agent to have contractual capacity because they don't have any liability that they incur as a result of this agreement or this sort of juristic act, unless it was agreed between the agent and the principal that the agent will incur liability, then that agent will need to have contractual capacity. If you don't have contractual capacity, you cannot incur personal liability. So in other words, a person of sufficient understanding may act as an agent. For example, a minor at this point in time can act as an agent. Remember, a minor cannot be a principal, okay, because the law of agency corresponds with the law of contract with regards to capacity. Can you enter into a valid agreement? If not, you cannot be principal under the law of agency, okay? But because in the law of agency, we say that the agent does not incur any personal liability, then that person who is an agent does not need to be a major or does not need to have contractual capacity in order for them to be an agent. So that's why we say that a person with sufficient understanding may act as an agent, and in this example, a minor. But remember, parties can still agree that the agent and the principal can still agree that the agent might incur some liability. If that is the case, then the agent will need to be a person who is of capacity to enter into contract, of capacity to enter into juristic act or perform juristic acts, okay? So where the contract could result in personal liability for the agent, then the agent will need contractual capacity. It is of importance that the duty of the third party to ascertain the extent of the agent's authority. So the principal must be in existence at the time that the contract is concluded. You know that sometimes a trustee or a person who is going to be a founder of a yet to be formed contract can enter into contract on behalf of a company that has not yet been formed. And under the Companies Act, those contracts are called pre-incorporated contracts. So have a look at page 286 of your textbook, where the case of Gardner versus Richard appears, where pre-incorporated contracts are discussed. And also, sometimes you might have a person acting as a nominee in a contract. And have a look at page 285 of your textbook, okay, where the party who had contracted as a nominee, the court held that he had contracted in his personal capacity with the right to assign it to someone else. Okay, and remember, guys, where we are giving case law, you don't need to go into detail or in that great detail with the case law. We just need to know how to use it as an example. What the textbook does is it makes it easier for you to engage with the material by giving you an example. And because this is a legal module, then they'll give you an example of a case on how courts then deal with this particular issue when it approaches the courts. So in certain instances, the agent must have written authority, meaning power of authority, and it could be attorney that is appearing in the High Court for a matter of litigation, and that authority must be in writing, and it must be in a form of a power of attorney. In terms of Section 2, subsection 1 of the Alienation of Land Act, it requires that the authority to sell and buy land must be in writing. We've already discussed this. And where the power is required or the power of attorney is required, it may either be a general power of attorney or a special power of attorney. Know the difference between a general power of attorney. Remember, with a general power of attorney, we say that it confers a very wide authority on the agent to act on behalf of the principal in respect of all the principal's affairs, whereas your specific or special power of attorney authorizes just that specific act, and usually it is just one juristic act. So the law of agency is especially relevant in dealings with companies and closed corporations, those who act through representatives. And we have already mentioned that the law of agency is mostly relevant to companies and closed corporations because they themselves cannot negotiate contracts on their behalf, but natural persons, representatives, can be directors, can be shareholders, can be partners, act on the business's behalf, and they are the ones who are negotiating those particular terms and conditions of the contract on behalf of the business. So the business acts through natural persons. So authorized directors or officers of the company act as agents of the company and they are authorized in terms of what a document that is called an Articles of Association. So if a person consults with you and say that I am authorized to act on behalf of so-and-so Pty Ltd, you will say you want to see an Articles of Association that appoints this person, okay, or gives authority to this person to act on behalf of the business. So partners also authority that bind other partners to transactions, okay? Transactions only that fall within the course and scope of the partnership's business. If you have a look at page 285, you'll see the case of Northview Shopping Center. In this case, the wife was a sole member of a corporation, and the husband then purported to sell immovable property that belonged to the closed corporation. And the question was whether he was duly authorized to act as an agent for the closed corporation. The court then explained that a member of the closed corporation authorized as such to sign in the same position as a functionary of the company, authorized to sign both without requiring authority. Okay, so a person authorized by the law is authorized as a functionary to act on behalf of the company or closed corporation, but an agent is authorized by expression of will. So a functionary does not require written authority to sell immovable property on behalf of a company or a closed corporation. An agent, as opposed to a functionary, can bind a closed corporation to a contract for a sale of immovable property only when there is written authority to do so. So have a look at the case of Northview and how companies or closed corporations or partnerships can be bound even if the person that acted on behalf of the company or the closed corporation did not have authority to do so. So the general method of determining where the alleged agent can legitimately perform a juristic act on behalf of the principal requires that the following questions be asked. Firstly, have all the formalities that are required to be complied with. Secondly, is there a principal who has contractual capacity at the time of concluding this juristic act? And thirdly, does the agent have capacity and the authority to represent the principal in those particular circumstances, or for that particular contract that the person is presenting themselves as an agent in? Okay, so guys, know this, especially capacity is very important. Capacity of the principal, capacity of the agent. Okay, can I get a thumbs up that we are still together on the law of agency? Okay, let's look at part 2. So with part 2, we are dealing with your formation of contracts of agency. We're going to talk about expressed authority. Then we're going to cover implied authority, authority by estoppel, ratification of authority, and delegation of authority. There are several ways in which authority can be created. It can be expressed, it can be implied, it can be authority by estoppel, or it can be ratification of authority. So we're going to go into detail with each of the types of authority, okay, or the ways in which authority can arise. Let's firstly deal with expressed authority. So with expressed authority, there's an agreement that can expressly authorize an agent to act on behalf of the principal, and this is usually in the form of actual authority. And in this form of authority, no formalities are required to appoint an agent. The agreement in express authority can either be oral or it can be in writing, and the terms may be expressed or the terms may be implied. And all that is required that the parties agree on is what must be done by the agent. Further, the parties must agree on the remuneration that must be paid to the agent, and the amount of remuneration may be expressed or it may be implied by trade usage. So for example, if I am a debt collector and I appoint an agent to collect debt on my behalf, and the trade usage is every time a debt collector collects a certain amount or a certain sum, they take 10% of that sum. So we might not agree how much remuneration I will give to that debt collector who's now my agent. But because of trade usage can be used to determine what can be charged as a result of it being used regularly in the trade. So in general, an agent is entitled to reasonable remuneration, and the factors that determine reasonable remuneration will then include the time and the labor by the agent, the value of the services that are rendered by the agents to the principal, and the nature of the agent's occupation, together with all surrounding circumstances for that particular case. With expressed authority, the principal may revoke that authority at any time, but if there's a revocation of authority at any time, there might be certain implications for the principal. So if it gives you an authority or gives you instructions and you prepare to execute those instructions, for example, you source out certain materials because you want to execute this particular authority that you've been given, and a few days later, the principal then revokes the authority that they've given to you, you'd have to claim damages from the principal. And that's what we mean by, if you revoke the authority that you've given to the agent, there might be some certain implications or damages that may be claimed against the principal. So in those particular circumstances, you look at the case of Consolidated Frame Cotton Corporation versus Setole, and it appears on page 286 of your textbook, where the contract provided that authority was irrevocable, and the court held that authority can still be revoked, although damages may arise to the revocation of the authority by the principal. Let's now look at your implied authority. So if the authority is not expressed, it can be implied in certain instances. So any other conduct that implies that the principal has conferred authority upon the agent will validly create an agency relationship between the principal and the agent. And this is also a form of actual authority. So the courts have recognized the validity of implied authority where the authority is a necessary component for the customary performance of the juristic act by the agent. So in the case of Nell versus SAR&H, where Nell then bought a car from F. F was living in Port Elizabeth. So the contract of sale was concluded, but then the car needed to be transported to Nell. And Nell said to F, can you send the car via rail? Okay. And now when he sends the car via rail, he, on top of that, included insurance for the car. So should something happen to the car along whilst it's in transit, then the car would have been insured. Nell then refused to pay F for that particular amount of insuring the car. And Nell has said, I did not give you authority to then pay for insurance. And this matter was taken to court. The court looked at the usual means of performing such mandates, and the court noted that the usual practice at the time where a product or a thing is sent via rail, the court held that if had no implied authority in those particular instances, an express authority covers only the usual means of performing the mandate. So if could not claim back what he was owed by Nell, because the court had decided that there was not implied authority. It did not amount to implied authority because the court looked at the practice at the time when the car was sent via rail. So where a principal knows that an agent is performing on his or her behalf, but does not object to it and allows the agent to continue performing the juristic act on his behalf, implied authority will said to have arose in those particular circumstances. So you look at the case of Kutsia, where Kutsia was a general dealer and Kutsia bought goods on account from one of his suppliers. So when Kutsia's son took over Kutsia's business, he continued buying on account from the supplier. And when invoices came to Kutsia, Kutsia refused to pay for these invoices. And his claim was he had never given authority to his son to buy on credit. But the court held that Kutsia was liable in those instances because his failure to stop the son on dealing on the account amounted to implied authority because it was done in front of his eyes and he had failed to stop it, and he let the juristic acts of buying an account to continue, and he did not put a stop to it. So the account had been sent to Kutsia, who had raised an objection, and the court said Kutsia in those circumstances was liable. So see the distinction between the case of Nell and the case of Kutsia. Okay, those cases appear on page 287 of your textbook. Let's look at authority by estoppel. So agency by way of estoppel is known sometimes as apparent authority or ostensible authority, and it arises where the agent does not have actual authority to act on the principal's behalf, but the principal is then estoppeled from denying that there was authority that was given to the agent. So the principal therefore becomes liable even though the agent was not authorized. So for example, if an employee acting without authorization then buys goods for the employer on credit, and the company then pays for the goods, and the act of payment could amount to a representation that the employee has the authority to enter into similar contracts on behalf of the employer in the future. So if you have given reasonable reliance to the agent that you accepting that particular performance, then you can be estoppeled from saying that you had not given authority. So the employer will be estopped from denying that the employee has the required authority to act on their behalf. So the principle of estoppel is based on fairness. So it arises where a person's conduct is such that it misleads another person. So if you as the principal then mislead the agent and then later on say that the agent did not have authority to act in that particular manner, you will be estoppeled, or the principle of estoppel will apply, or you will be stopped from denying that you have incurred liability in those particular instances. So if the principal represents or permits it to be represented to the third party that the agent has authority to enter into a certain transaction on behalf of the principal's on the principal's behalf, then the innocent party acting in reasonable reliance. So what's important with estoppel is reasonable reliance on this representation. It's thereby induced into the transaction, and the principal will then be stopped or prevented from relying on the fact that the agent lacked the necessary authority to enter into that particular transaction. So there are requirements. When estoppel is raised, requirements must be satisfied. So these are the requirements that must be satisfied. Please note the requirements, very important, the 5 requirements, and highly testable. Okay, so the first requirement is that representation by the agent that he or she has mandated to act for the principal, and it means that the representation may be by words or it may be by conduct, and the agent must hold him or herself out to have authority that will bind the principal. So if there was no representation as such, okay, for example, I am the agent, the third party will then see themselves as contracting with the person with whom they are dealing with and not with the agent of another. So look at the case of Strachan that appears on page 288 of your textbook with regards to the requirement of representation by the agent that he or she has mandated to act on behalf of the principal. Then the second requirement will be representation by the principal that the agent is authorized to bind the principal. So this requirement means that a person will not be bound by the act of one self-styled agent, and the representation may be by words or by conduct, just as the first requirement. Look at the case of Winden and the case of Northern Metropolitan Local Municipality that appear on page 288 of your textbook as an example of the second requirement. The third requirement, and this is very important for estoppel, is reasonable reliance. So it must have been objectively reasonable for the third party to have relied on the representation in concluding the contract. So in addition, the words or conduct must have been such that they could reasonably be expected to mislead. In the case of Monzali, that also appears on page 288 of your textbook, gives a better understanding of how courts will then apply reasonable reliance should a matter then come to court with regards to estoppel or the principal being prevented or stopped from denying that they actually gave ostensible authority. Also, the case of Quinn and Company that appears on page 289 is a very good example and illustration of how the acts then react to cases when they are looking at authority by estoppel with regards to reasonable reliance. Then another requirement will be inducement. It means that the representation by the agent must then have induced the third party to enter into that contract or to act. So a representation alone is not enough. There must be a connection between the representation and the decision of the third party to enter into that contract. So the act or the persuasion must have resulted in the third party entering into that contract, okay, or binding themselves into that contract. Look at the case of Southern Life Association. Remember, the representation alone is not enough. There needs to be a contract that was entered into and that bound the third party and the principal. And the last requirement is detriment. The contract must have been to the detriment of the third party. And the case of Peri-Urban Areas Health Board versus Brit appears on page 289 of your textbook. Okay, these are very important, guys. So know the 5 requirements of estoppel, know how to discuss them with regards to cases. And like I said, when you are required to discuss an example with regards to these requirements and you need to make reference to case law, you don't need to go as deep into the case law. You just merely need to give your understanding as the textbook gives you, like that particular paragraph of the case that is relevant to a requirement or the requirements that appear here for estoppel. So as far as the third party is concerned, it makes no difference whether the agent is held to be had implied authority or ostensible authority. So both cases, the principal will be bound, and the distinction between implied and ostensible authority will then be important for the agent and the principal. So implied means that the actual authority was given and acted within the scope of the mandate, and the ostensible authority will mean that the agent acted outside of the scope of the mandate, but the principal is estoppel from raising the absence of authority in those particular circumstances. So the agent could be liable in damages to the principal for breach of mandate if it's ostensible authority, not if it's implied authority. Okay, let's now look at ratification of authority. So with ratification, we're looking at the agent acting and representing himself to the third party as if he or she had authority from the principal, but did not actually have authority at the time of entering into a contract, okay? And then the principal comes to know of that particular contract and rectifies it, then agrees to enter into the contract. So that is ratification. But we'll also look at instances where the principal now comes to know of that particular contract that they did not authorize, but they actually deny entering into that contract, and they say that I'm not rectifying this contract. In fact, I did not give authority for this contract. So ratification can arise when an authorized agent has represented that he or she has actual authority, and that the third party has contracted in the belief that the principal will be bound. There is no real representation by the principal to the third party. The agent has no authority to bind the principal, and the principal is not bound in law. Ratification then allows the principal to choose to accept the contract and become liable thereon, okay? So we know that the principal can then accept the act of the agent, which he or she previously did not authorize to happen, okay? And that is called ratification. So if ratification occurs, the legal position as with regards to the principal and the third party is the same as if the principal had given authority at the time when the contract came into being. In other words, ratification will then operate retrospectively. There are certain requirements that need to be met with regards to ratification of authority, and you need to know these requirements. So firstly, the act must be capable of ratification. So it must be that it is something that could have been entered into by an authorized agent. For example, if you're talking about your illegal and immoral contract, that cannot be ratified because it cannot be legally entered into, or that contract will not be legal to enter into. Secondly, the unauthorized agent must have represented that he or she had authority. So at the time the agent acted, he or she must have represented to the third party that he or she was authorized to act on behalf of the principal. And if the principal was unnamed, only that person could rectify. So thirdly, Third requirement, the principal must have been in existence at the time that the contract was entered into. And this is based on agency and consent, and the person who is not in existence cannot then give that consent, okay? Your requirement number 4, rectification must be done by the principal. The principal must then rectify the unauthorized act with full knowledge of the material fact and the intention of confirming the agent's act, whatever they might have been. And rectification may be expressed or implied. It will be implied in circumstances where only reasonable interference can be drawn from the conduct of the principal that he or she intended to rectify and to become liable in terms of the contract. Rectification cannot be partial, so you can either choose to rectify the entire contract or not rectify at all. You can't pick and choose as a principal, oh, I'm rectifying clause 1 and 2 only and the rest I'm not rectifying. You can either pick to rectify everything or nothing at all. And lastly, rectification must be made within the specified time. And if no time is specified, it must be made within reasonable time. So it must be noted that if an authorized agent exceeds his or her authority, this constitutes a breach of mandate, and that will be now an issue with regards to the contract between the agent and the principal. And the principal who elects to rectify does not waive his right to dismiss the agent at a later point in time. Okay, I know that we've run out of time, but you guys can go through delegation of authority, how authority is delegated, what's the general rule, and what's the exception with regards to your delegation of authority. Quickly, before we close off, I want us to look at part 3 and what part 3 actually deals with. Just to do the topics of part 3. Okay, it deals with the duties of the agent. So what are the duties of the agent, the person who is given the authority? So it's to perform the authority as given, or to perform the act, okay, that is given by the principal. And secondly, to keep proper records for the principal. So if the agent acts on behalf of the principal, they must keep proper records, and they must also show utmost good faith. So if you trust someone enough to give them authority, they must in return act in good faith. So those are the duties of the agent, and you can go through your notes and supplement your notes with your textbook at what are the duties of the agent. And then look at the duties of the principal. What are the duties of the principal? The principal must pay remuneration, okay, to the agent. Okay, remember, remuneration must be reasonable remuneration. Also, the principal must reimburse and indemnify the agent for the expenses or losses that that the agent might have incurred in performing this authority that was given to the agent. And then look at the rights and liabilities of third parties. There you're going to look at named principals, unnamed principals, and undisclosed principles. And then you look at the termination of agency. How does agency terminate? And you'd know that obviously it will terminate once the authority has been completed by the agent. It will also terminate if the parties, the agent and the principal, agree to terminate the contract of agency, or when the expiry date of the authority comes about, it may terminate then, or the insolvency or death of an agent, or the insanity of an agent if an agent becomes insane, or if there's supervening illegality or impossibility, then the law of agency will automatically terminate in those instances. Okay, are there any questions, guys? If there are no questions, I wish you all the best for the upcoming test. And should you have any questions or issues before the test, which is today after this lecture, you may email me and we can set a one-on-one consultation and we can talk about it. Okay, thank you so much. I will see you guys next week.